Welcome to the Law Offices of Chris M. Ingram's Immigration News Roundup podcast. Today, we are going to talk about President Trump's plan, announced on Friday, September 19, 2025, to raise the application fees for a graduate H-1B visa from around $3,000 per application to an unimaginable $100,000 a visa application. What is going on? We want to thank attorney Chris M. Ingram and his team, who have worked very hard in preparing this podcast from a wide variety of news sources from both sides of the aisle at short notice. Great job. Attorney Ingram is also a vocal advocate for the rights and protection of immigration applicants. Our coverage is designed to be nonpartisan. Please do not forget to give us a like, follow, and subscribe to this channel. We are also on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. You can also visit our website on www.breakthroughUSA.com. We'd love to see you there. If you, a friend, or a family member would like a free consultation, you can visit our website at www.breakthroughUSA.com and schedule an appointment. We'd love to hear from you and help you if we can. Okay, let's dive in. Okay, so let's dive into this this H-1B fee bombshell. The first crucial point, I think, is that this huge policy shift, the one announced September 19th, 2025, wasn't a law passed by Congress, was it?
No, absolutely not. And that's really key to understanding the immediate chaos it caused. It seemed to just, bypass the whole Democratic debate.
Right, so we're sort of in a legal gray area here. A massive policy change almost overnight, just based on executive action.
Pretty much. It relies purely on an executive mandate.
So what exactly was the legal tool they used? And, where does the executive branch even get the authority for something like this?
Yeah, that's the critical piece. The mechanism was a presidential proclamation, specifically titled The Restriction on Entry of Certain Non-Immigrant Workers. Now, proclamations can sometimes sound just ceremonial, but they get real teeth when they leverage specific legal authority that Congress has delegated to the president.
And a proclamation isn't the same as an executive order, right? Our legal team's research really flagged that distinction as important, especially thinking about, legal challenges.
It is super important. An executive order, or EO, usually tells federal agencies how to enforce a law that already exists. Think back to the 2017 travel ban EO, for instance, which got tangled up in the courts and restructured. A proclamation, though, while it's also a formal announcement, in this case, it's leaning on much broader authority found in the Immigration and Nationality Act, the INA. Specifically, it's using Section 212.
Section 212, and what does that actually allow the president to do?
Okay, so 212F gives the president the power to suspend the entry of any group of non-citizens if their entry is deemed detrimental to the interests of the United States. It's a huge grant of power, honestly, and often controversial, typically used for things like national security or public safety. But here, the administration is basically using it to say that entry by H-1B workers without paying this enormous $100,000 fee is detrimental. So it instructs DHS, Homeland Security, to deny petitions that don't include the fee.
Wow. So they're framing the lack of the fee as the reason for denial, using that INA power to restrict entry. Well, it's clever, I suppose, but it sounds immediately like something that could be challenged in court.
Oh, absolutely. It is. Critics are already making the case that this is really substantive policy change disguised as just an entry restriction. A massive recurring fee hike like this would normally need formal rulemaking under the Administrative Procedure Act, the APA. That means public notice, a comment, period.
Whole process.
Exactly. By skipping Congress and the APA, this proclamation is wide open to lawsuits arguing it's arbitrary and capricious. Tech companies, immigrant rights groups, they're already lining up, which means the actual rollout could get seriously delayed or maybe watered down. It just adds more uncertainty for employers right now.
And that uncertainty was definitely amplified by the speed, wasn't it? Our team pointed out the effective date was almost immediate, like 2 days after signing. Companies had zero time.
Zero time to audit, restructure, plan, anything. That speed wasn't an accident, I don't think, but it certainly cranked up the chaos style. You had companies with employees traveling, suddenly scrambling, trying to get them back before they'd be subject to this huge fee on reentry. But, this whole disruption kind of brings us back to why people seek this status to begin with, and what Chris Ingram sometimes calls the tipping point.
Right. His insight about the pioneering spirit of immigrants.
Exactly that. Chris often reflects on the whole American story, the idea that generations came here, faced huge challenges, but built incredible things in return. This fee, though, It sets up this potentially massive financial and maybe ethical barrier. It could change that fundamental calculation. It's not just the 100 grand, it's the message it sends about how much that contribution is valued. When the price tag is $100,000 a year, the hardship might just start to outweigh the dream. The real risk, Chris argues, is reaching that tipping point where the world's best talent just decides, you know what, maybe I'll invest my future somewhere else.
That's powerful context. Okay, let's maybe sit back for a second and just make sure everyone listening understands the visa itself, the H-1B. We hear a lot about it, but what's its actual job in the U.S. economy?
Yeah, good idea. So the H-1B visa is basically the main way the U.S. brings in highly skilled professionals to fill what are called specialty occupations. And these aren't just any jobs.
Right. When you say specialty occupations, we're talking roles that demand pretty high academic or technical skills.
Correct. The job itself has to require, at minimum, a bachelor's degree or its equivalent in a very specific specialized field. Think cutting-edge stuff. AI modeling, biotech research, complex cybersecurity, advanced data science. And there's a crucial protection built in. The employer must pay the prevailing wage for that job in that specific location. That's to make sure H-1B workers aren't used to undercut local salaries.
And it's interesting, despite all the noise around it, the actual number of new H-1Bs each year is pretty small compared to the overall economy.
It's surprisingly modest, yeah. The annual cap for new H-1B visas is just 85,000. That breaks down into 65,000 for the general pool, and then another 20,000 specifically set aside for people who got an advanced degree, a master's or PhD from a U.S. university. For an economy our size, 330 million people, a huge labor market, 85,000 new visas a year, it's really just a trickle. Demand always swamps the supply, which is why they have that lottery every spring.
And the length of the visa? It's not like it's an automatic path to a green card either, is it?
No, not at all. Status is usually granted for up to 6 years total, typically in 2 chunks of 3 years. But, and this is where it gets really complicated, especially for workers from countries like India and China with huge green card backlogs. If they have an approved green card application, like an EB2 or EB3, they can get stuck waiting for years because of per-country limits. In those situations, their H-1B status can be extended beyond the 6 years, sometimes indefinitely, until their green card spot actually becomes available. That extension mechanism is what keeps millions of skilled workers here, driving innovation while they wait.
Okay, let's get back to the money then. Before this proclamation, the fees, they were investment, sure, but generally manageable for businesses, right?
They were. You had the base filing fee, a training fee that actually funds U.S. worker training programs, and a fraud prevention fee. Throw in legal costs, and the total was usually somewhere between, say, $2,500 and $5,000 per petition. A serious cost, yes, but a manageable business expense for getting highly specialized talent.
And now, it's just astronomical jump. $100,000 annually per petition, specifically for entries or re-entries. That's what, a 20 to 40 times increase overnight?
It's instantly prohibitive. Just think about it practically. Say you're a mid-sized software company hiring a good engineer. Prevailing wage might be $120,000. That $100,000 fee, it eats up 83% of their first-year salary right there. For a startup running on maybe a couple million in seed funding, forget it. Spending $300,000 up front just to hire 3 developers. That's basically a death sentence for the company. It prices out everyone except maybe the absolute wealthiest tech giants. And even for them, it's a huge, recurring $100,000 annual tax on just one employee they need.
And that detail about whether it applies to renewals if the employee doesn't leave the U.S., that seems to be causing massive confusion and paralysis, too.
Precisely. Companies are scrambling for clear guidance, but the language seems focused on entry or re-entry. That suggests any international travel, visiting family, attending a global conference could trigger the fee when they come back. So it effectively traps current H-1B holders inside the U.S., right? Limits their mobility, limits how global companies can operate. It's a huge mess.
This really feels like it goes way beyond just paperwork fees. It starts hitting at America's whole competitive edge, doesn't it? Let's dig into why the H-1B is actually so important for U.S. innovation and the economy.
Yeah, it's fundamental. Our legal team's research really confirms how indispensable the H-1B program is. We know the big tech hubs, Google, Microsoft, Amazon, they rely on H-1Bs to fill something like 70 to 80% of their foreign-born engineering roles. And these folks are mostly coming from places like India, which got 71% of the approvals in 2024, and China.
And this isn't just preference, right? It's structural. There's a real gap in the U.S. labor supply for some of these super specialized tech skills.
There absolutely is. Our universities produce great talent, don't get me wrong, about 140,000 STEM grads a year. But that just doesn't meet the sheer demand for expertise in fields like quantum computing, or advanced AI, or large-scale cybersecurity.
So why did you choose the law offices of Chris M. Ingram as your attorney?
Honestly, they made it feel like I was never on my own.
Every time I had a question, someone actually answered. They cared.
We never felt alone. The videos felt like we had someone with us the whole way. Every form, every question, they had a video that explained it.
It made the process so easy.
Our tutorials are designed to get you over the finishing line, and after watching them, you are reassured that you have completed that section correctly.
At the law offices of Chris M. Ingram, our mission is to support you. Our instructional videos will guide you every step of the way. So join us.
Historically, the H-1B program has been the bridge, bringing in the necessary talent to keep the U.S. at the forefront technologically.
And beyond just filling jobs, there's evidence these workers actually create more economic activity, right? A multiplier effect.
Yes, studies consistently show that. Because of the prevailing wage rules, it's generally not about displacing U.S. workers. Instead, bringing in a high-skilled H-1B worker often opens up new business lines, new projects, creating, on average, about 1.8 additional U.S. jobs for every H-1B hire. Those are jobs in management, support, sales roles that exist because that core innovation engine, often fueled by H-1B talent, is running. Slap a $100,000 tax on that engine and you slow down job creation everywhere else.
Which explains the sheer panic we've seen from industry. Real warnings about a potential brain drain.
The warnings are definitely severe. Some analysts crunch the numbers. If all 730,000 or so current H-1B holders eventually got hit by this fee structure, maybe through re-entry or new filings, that's potentially a $73 billion tax on U.S. companies. Bindu Reddy, the CEO of Abacus.ai, she put it bluntly on social media, saying U.S. tech dominance just took a massive hit and predicting an immediate shift of talent towards India and China.
And it's not just tech, is it? We're seeing potentially huge problems in really essential sectors like healthcare.
Oh, the potential impact on healthcare is just devastating to contemplate. Dr. Nick Mark's analysis, which our team looked at, highlights that almost 30% of U.S. medical residents, the doctors training in hospitals, are international medical graduates. And crucially, about 10,000 residency spots each year are filled by doctors on H-1B visas. Now, residents, they get paid maybe $55,000 a year. No hospital, especially nonprofits or community hospitals that really rely on international grads, can possibly afford to pay a $100,000 annual fee on top of a $55,000 salary. It just doesn't work. This policy could basically wipe out thousands of essential residency positions overnight, crippling staffing in ICUs, internal medicine, rural clinics, everywhere.
Yeah, you can see why this is so politically charged. Our research has pulled together views from across the spectrum just to show the range of the debate, staying nonpartisan, of course.
Right. So on the center left, the reaction was mostly about the impact on innovation, the unintended consequences. You had Representative Raja Krishnamurthy calling it reckless. Senator Bernie Sanders, who usually focuses hard on worker protections, called it unfortunate and short-sighted, arguing it actually stifles innovation without fixing underlying wage issues that sometimes pop up.
And how about supporters? How did they frame it?
Supporters, folks like Senator Tom Cotton, tend to frame it as putting Americans first. The argument is it forces big companies to pay a steep price, maybe even a punitive one, for choosing foreign talent over Americans, like a protective tariff, essentially. But it's interesting, you also had voices like Representative Rokana. He supports stronger worker protections, but he warned this specific fee was a self-inflicted wound to Silicon Valley, showing more pragmatic concern about the economic damage.
And when you look at academics, researchers, the consensus seems pretty heavily tilted towards worrying about the hit to America's global standing.
Absolutely. Vivek Wadhwar at Carnegie Mellon flat out called it sabotage. He pointed to research showing H-1Bs fuel something like 25% of U.S. patents. His worry is that by pushing this talent away, the U.S. is basically handing leadership in critical fields like AI directly to competitors. And there was a Stanford study predicting a 15% drop in foreign student enrollment in U.S. STEM grad programs by 2027. So the pipeline for future innovation is already getting hit by the uncertainty.
Now, Chris Ingram offered some important perspective here too, didn't he? Kind of tempering the panic by looking at the scale versus the impact.
That's crucial. As Chris pointed out, the 85,000 new visas each year, that's highly regulated, prevailing wage rules apply, it's not some kind of invasion. The real immediate worry is the fate of the, several million H-1B visa holders already here doing essential, specialized work. Their stability is what's really at risk, and that threatens the core specialty jobs across the economy.
Okay, the numbers are scary, potential losses are huge, but companies aren't just sitting around, right? This brings us to probably the most important part for listeners. What practical steps, what proactive moves are our attorneys seeing employers make right now to get around this fee and the H-1B cap? What are the alternatives?
This is where strategy is everything. The market's shifting fast, and companies that pivot quickly will likely snap up the best global talent before these other pathways get overloaded or face more scrutiny. Our attorneys are really focusing on 4 main routes right now. Direct green card sponsorship, that's the EB-2 and EB-3. Then you have intracompany transfers, the L-1A and L-1B. Third is the O-1A visa for extraordinary ability. And finally, the EB-2 national interest waiver, or NIW, which is self-petitioned.
Okay, let's break those down. Alternative 1, direct green card sponsorship, EB-2 or EB-3. This is often the end goal anyway, but it needs a big commitment from the employer up front, doesn't it?
It really does. The employer has to definitively prove there's a shortage of qualified U.S. workers for that specific job. And they do that through a really rigorous recruitment and certification process called PERM, Program Electronic Review Management. It's not just posting an ad.
Can you say more about PERM? What does that actually involve? It sounds tough.
It is demanding. PERM is like the ultimate labor market test. The employer has to define the job duties very carefully, get a specific prevailing wage determination from the Department of Labor, and then conduct mandatory recruitment steps. That usually means posting with the state workforce agency, running 2 Sunday newspaper ads, plus other steps depending on the job, and then proving they genuinely interviewed any qualified U.S. applicants and had lawful job-related reasons for not hiring them. That whole PERM process, just to get certified before you even file the actual green card petition, can take anywhere from 6 to 18 months.
Wow, that's a serious time investment. Let's look at that case study. Dr. Elena Vasquez and TechBridge Solutions. How did they use EB-2?
Right, TechBridge, the AI firm in Austin. They needed a lead researcher in quantum-inspired algorithms, super specialized stuff. Instead of risking the H-1B lottery or this new fee, they went straight for an EB-2 sponsorship for Dr. Vasquez, who has a PhD and is from Spain. They defined the role very specifically. PhD plus 5 years of postdoc research in quantum machine learning. Then they did the whole PERM recruitment campaign, documented that no qualified U.S. workers had that specific skill set, and then filed the green card petition.
And the payoff for TechBridge compared to the H-1B fee?
Well, for Elena, being from Spain, there's no major green card backlog. So the whole process, PERM plus the I-140 petition approval, might take around 18 months total, the cost. Under $10,000 in legal and filing fees. Compare that to $100,000 every year for an H-1B. TechBridge gets a permanent employee who can mentor U.S. engineers and significantly boost their research. Our legal team often suggests combining this longer-term EB-2 path with a faster temporary visa like the O-1A for immediate entry, if possible. It's a good strategic combo.
That makes sense. Which brings us neatly to alternative 2, intra-company transfers. The L-1A for managers, L-1B for specialized knowledge workers. For big multinational companies, this must look really appealing right now.
Incredibly appealing. L1s have no annual cap, and they don't require that whole PERM recruitment process. L1A is for managers or executives who worked for the company abroad for at least 1 year in the last 3. Gives them up to 7 years here. L1B is more common for technical folks. It's for employees with specialized knowledge, meaning expertise that's unique or proprietary to the company. That gives them up to 5 years.
Okay, that sounds almost too good to be true compared to the H-1B mess. Why aren't all companies just using L1s then? What are the catches? What stops it from being a universal fix?
That's a fair question. The biggest limitation is that requirement for prior foreign employment with the same company or an affiliate. You need a stable foreign office, and the employee needs that 1 year of qualifying work experience abroad within the last 3 years. That immediately rules out 2 huge groups. International students graduating from U.S. universities who don't have that prior foreign work history, and purely domestic U.S. companies that don't have any foreign operations to transfer people from. So L1 really works best for established multinationals.
Gotcha. Let's look at the global fintech example, using L-1B for Raj Patel, the cybersecurity engineer from Bangalore.
Right. So Raj had worked for 3 years in Global FinTech's Bangalore office. He'd developed these proprietary encryption protocols for their blockchain system, really specific, valuable stuff. Global FinTech filed for an L-1B, showing USCIS that Raj's knowledge was unique, like his custom scripts cut their system's false positives by 60%,
Right.
and that this knowledge was essential for their New York team. You really need that level of detail to make the case for specialized knowledge.
And the result for them?
L1 processing is generally quicker. They likely got approval in about 3 months, cost maybe under $6,000 total. Raj comes to the U.S., trains 5 American analysts on his methods, helps launch a new, secure product, potentially boosting their market share significantly. It shows how L1 lets them bypass the cap and the fee, leveraging their global talent effectively here.
Okay, moving on. Alternative 3. The O1A visa for extraordinary ability. This sounds like it's for the real rock stars, the people at the very top of their game. Maybe they don't work for a giant multinational.
Exactly. O1A is aimed at individuals who can demonstrate extraordinary ability in fields like science, education, business, or athletics. It means you have to show sustained national or international acclaim. You're recognized as being one of the very best in your field. Like the L1, there's no annual cap, no PERM recruitment needed. The U.S. employer sponsors the petition.
How do you prove extraordinary ability? You mentioned they need to meet criteria from a list.
Yeah, USCIS has a list of criteria, and you generally need to meet at least 3 of them. Things like receiving major awards, think Nobel, Pulitzer, but lesser nationally recognized awards count too. Having articles written about you in major publications, playing a critical role in distinguished organizations, commanding a very high salary compared to others in the field. Evidence of original major contributions, patents, significant research. The evidence has to be really solid.
You finally got your family together on a H-1B. Your American dream begins. Your employer files for your EB-2 green card, but the wait is over 11 years. As the years go by, frustration grows, and now the company is talking about layoffs. This could be the end of your American dream. You search for help, but luckily, you land on BreakthroughUSA.com. They listened, reassured you, and built your EB-1 case with precision. Then one day, a notification buzzes, EB-1 approved. With your EB-1 green card, your entire family can breathe.
I have got my visa. I got my visa.
That's why the law offices of Chris M. Ingram is trusted. Your future shouldn't wait. Let's talk EB-1.
What are the next steps?
Need help with your visa? Book your free consultation now at www.breakthroughUSA.com and let us take care of you.
Let's use the BioNova Labs case with Dr. Sofia Mendes, the Brazilian gene editing prodigy.
Dr. Mendes was a perfect O1A candidate. Even though she was young, maybe 28, she had incredible achievements. A major award like the Lasker, lead author on 20 papers in top journals like Nature. She'd been interviewed by the BBC about her work. Clear international acclaim. BioNova Labs gathered all that evidence, expert letters from leaders in her field, the media clips, proof of her previous high salary, and filed the O1A petition.
And the benefit for BioNova?
Immediate access to truly world-class talent. Approval probably came in just a couple of months. Her work on a safer gene editing technique sped up their clinical trials by over a year, which directly helped them raise $30 million in funding and hire 10 local U.S. staff she could train. The cost for the O1A. Maybe around $4,500. It really shows how these targeted visas used strategically can be huge economic drivers and create U.S. jobs, completely bypassing the H-1B issues.
Okay, our last alternative, number 4. The EB-2 National Interest Waiver, the NIW. This one's different because the worker can petition for themselves, right?
Yeah.
No employer sponsor needed.
That's right. The NIW is a potential lifeline, especially for researchers or entrepreneurs whose work serves the broader U.S. national interest. It allows them to self-petition for a green card, completely bypassing the need for a specific job offer and the whole PRM labor certification process.
What do you have to show to qualify for a national interest waiver? How's that judged?
The standard comes from a key administrative decision called Matter of Donisar. It sets out a 3-pronged test. First, The person's proposed work must have both substantial merit and national importance. Think advancing health, the economy, energy independence, things like that. Second, the person must be well positioned to actually advance that work based on their skills, track record, resources. And third, they have to show that, on balance, it would benefit the U.S. to waive the normal job offer and PERM requirement. Basically, is their contribution potentially so important that making them go through the lengthy recruitment process doesn't make sense for the country?
And what about the timeline? And are there downsides?
For people from most countries, again, except for India and China, who face those huge backlogs, the NIW can be a relatively quick path to a green card, maybe 1 to 3 years total. For Indian and Chinese nationals, getting the NIW petition approved is still valuable because it usually lets them keep extending their current status, like H-1B, indefinitely while they wait for their green card number. But the wait for the actual green card can still be a decade or more. The main downside, from an employer's perspective, if they support the petition indirectly, is that once the person gets the green card, they're a free agent. They can leave. So there's a retention risk.
Let's illustrate with Dr. Lucas Hoffman and Clean Energy Innovations.
Yeah.
How did the NIW work there?
Dr. Hoffman, the German renewable energy expert, was working on these super efficient perovskite silicon solar cells. His goal was to cut solar costs by 30%, directly helping U.S. energy independence. Facing the H-1B uncertainty, he decided to self-petition for the NIW. He put together a strong case, a business plan projecting 50,000 U.S. jobs if his tech scaled up, endorsements from the Department of Energy, evidence of his 12 key patents.
Yeah, because he was self-petitioning.
Right. And being German, he didn't face a final visa backlog. His green card likely came through in about 14 months. His lab then got a $5 million federal grant. He trained 8 U.S. grad students, spun off a couple of local startups. Even though Clean Energy Innovations technically risked losing him once he got the green card, they benefited immensely from his presence and the IP he developed while there. And as Chris Ingram often advises, the NIW is a crucial tool. It forces companies to think about building teams based on merit and national need, not just visa availability. You accept the turnover risk for the massive potential upside.
Okay, so we've covered the strategies, the alternatives. But what happens if companies can't pivot? Or if they just choose not to deal with these other complex visas? The big fear seems to be a massive wave of offshoring, right? This fee just completely changes the economics.
It creates what our team started calling the new math. Think about it. An engineer in India might earn, say, $20,000 to $50,000 a year. The prevailing wage for a similar engineer here could easily be $120,000. Now add a $100,000 annual entry tax on top of that U.S. salary. Suddenly, hiring remotely in India isn't just an option, it becomes an economic necessity for many companies. The cost savings are just too huge to ignore.
And the technology for remote work is so good now, the distance doesn't matter as much for a lot of these tech jobs.
Exactly. McKinsey had already projected that even before this fee, maybe 45% of U.S. tech roles could become hybrid or fully offshore by 2030. This $100,000 fee. It could easily accelerate that, push it towards 60% or even higher. It basically fast forwards the departure of high-wage, specialized jobs from the U.S.
But while companies might save 40–60% on labor costs initially, our research flagged a really big hidden cost, didn't it? A cost to innovation itself.
Yes, there's a steep hidden price. A Harvard Business Review study from 2024 found that R&D teams that are physically located together onshore tend to innovate about 25% faster than remote, globally distributed teams. That speed comes from spontaneous collaboration, the water cooler moments, the quick feedback loops you just can't fully replicate over scheduled video calls. So when you offshore aggressively, you might keep the management and marketing here, but you risk exporting the core R&D, the actual invention process.
So like that real with the Apex Dynamics case study, the startup in Seattle.
Right. Apex Dynamics, promising software startup, got $2 million in seed funding. They planned to hire 3 crucial H-1B developers to build their main product. Suddenly, they're facing $300,000 in upfront visa fees for those 3 people. That's 15% of their entire seed funding gone before they even write a line of code. It's a complete non-starter, guarantees failure.
So instead of hiring in Seattle,
their only real option was to pivot immediately. They opened a small 10-person office in Chennai, India, hired local engineers there at maybe $30,000 salaries. The product still gets built, yes, but Seattle loses those 3 high-wage jobs, maybe $360,000 a year in local salaries, taxes, spending power gone. The local tech scene loses the mentorship, the potential spin-offs. Fast forward a couple of years, Apex could easily have 70% of its operations offshore. It becomes just a U.S. headquarters, a shell. It's exactly what Chris Ingram meant by that chilling phrase. The Rust Belt decline, but for code.
That analogy really hits home. And Chris views this whole policy as basically profound self-sabotage for the U.S., doesn't he?
He does. His point is that this doesn't actually protect U.S. jobs. It just sends them elsewhere, while simultaneously weakening the very specialized ecosystem here that employs millions of Americans in related roles. And globally, the winners are pretty clear. India is reportedly absorbing maybe 200,000 returning tech workers annually already. China's offering subsidies to lure talent back. Europe is pushing things like the EU Blue Card. The Brookings Institution even modeled a potential 0.7% drag on U.S. GDP by 2030 just from this kind of brain drain. That's over $200 billion in lost economic activity.
Wow. Okay, amidst all that gloom, are there any silver linings? Can anything positive possibly come out of this kind of crisis?
Well, maybe two potential silver linings. First, a shock to the system this big might finally force Congress to act on real systemic immigration reform. Specifically, that fairness for high-skilled immigrants Act, the one that aims to get rid of the per-country green card caps that caused those huge backlogs for India and China. With the H-1B route so broken by this fee, maybe there's finally enough pressure to fix the permanent residency system. Second, companies are now absolutely forced to get creative and invest seriously in those alternatives. We talked about the L1, O1, and IW. And maybe, just maybe, it also forces them to invest more in developing local talent pipelines through apprenticeships, better training programs. So this forced diversification, while painful now, could ultimately make the whole system more resilient and balanced in the long run.
That's a really interesting final thought. The pioneering spirit that, built America, it's being tested now, not by the traditional challenges, but by a $100,000 entry fee. The knowledge we've shared today about these alternatives, L1, O1, EB2, NIW, the demands of PERM, it's absolutely crucial right now. The challenge for you, listening, is how to apply this knowledge proactively. How to guide your company's strategy or maybe your own career path to make sure that this vital specialized talent continues to be part of America's future despite these roadblocks. Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together. Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this material for our presentation. If you, a friend or a family member would like a free consultation, you can visit our website at www.breakthroughUSA.com and schedule an appointment. We'd love to hear from you and help you if we can. See you next time on Let's Talk U.S. Immigration. Bye for now.